Okay, our next case will be In re Lisa Gorcyca versus Judicial Tenure Commission. Please.
Chief Justice Marpin and Justices of the Court, good morning. My name is Tom Cranmer, and along with Chris Hildebrand, I have the privilege of representing Judge Lisa Gorcyca in this matter. Your Honors, the idea of putting things into context is important. It's important in a judicial sense. I think it's also important in everyday life sense. And if you take things out of context, there's a great danger that you're going to come to an erroneous conclusion. And I'm sure by now you've each had the opportunity to take a look at the 22 or 23-minute video that essentially encompasses the entire commission case in this matter, a case which has existed and has been ongoing for more than 5 years. And I respectfully submit to the Court that in order to reach the right conclusion in this case, and that is whether or not there was judicial misconduct that was committed by Judge Gorcyca, you have to put that video into its proper context. I suppose there aren't many things that I agree with in terms of the Commission's report to this Court, but I certainly agree with their characterization of the underlying Simone case as being extremely contentious, in its own way complex, and very acrimonious. If you went and you printed out the Register of Action in this case, it's 27 pages long. There are more than 100 pleadings that were filed in this case, more than 40 court hearings. The plaintiff mother in this case, by the time of this particular incident on June the 24th of 2015, had gone through 16 different attorneys. Defendant father had gone through 4. There were 78 separate orders that were entered in the case. More than 30 of those dealt with this contentious issue of parenting time. And again, as the Commission report properly notes, most of those orders, the vast majority of those orders, were simply attempts to level the playing field, to allow the father to have appropriate parenting time. And most of those orders were thwarted by the actions of either the mother or the children. On June the 24th of 2015, the date that brings us before the Court today, Judge Gorcyca was again attempting to employ an extraordinary remedy in terms of effectuating parenting time. She was actually having parenting time in her jury room, where she could be close at hand and have the assistance of other people, other court members, assist in terms of seeing that the parenting time was actually real and effective. But that wasn't the first time that she had gone to this extraordinary measure. She had tried this at the suggestion of the parties back in August of 2014. And up until this time, literally nothing was working. She tried all different kinds of alternatives. She tried parenting at each of the parents' homes with a variety of different therapists, with friend of the court personnel, in public settings, at libraries and restaurants, at friends' homes. She had tried everything, and nothing was working. But back in August of 2014, she decided to kind of take the matter into her own hands and see if she couldn't do something to make sure that the parenting time was being effectively utilized. So she ordered the parties to come to court. And when they came to court, the children refused to enter the courtroom because their father was in the courtroom. They sat outside in chairs outside the courtroom, next to one another, and literally locked arms, looked down at the floor, refused to go into the courtroom, and refused to do anything in terms of following the court's order. Judge Gorcyca sent out 6 different Oakland County Sheriff deputies to try to convince the children to come into the courtroom. Didn't work. She sent out a friend of the court counselor, Tracy Steve, to try to get the children to come into the courtroom. Didn't work.
Counsel,
Yes.
are you the impression that we haven't read and are familiar with the factual predicate of this case?
No, I'm sure.
You've had 5 minutes and you haven't advanced a single argument in support of your client's position. I have read and I understand the factual background. This is a horrible, horrible and aggravating case. Tell me why. Here, let me just tell you 2 things I'm concerned
Please.
about. I'm concerned about the Commission's conflation of legal error, if any occurred here,
Yes.
with ethical violations, which is its turf. And I'm concerned that your client has never once acknowledged or admitted that perhaps she lost objectivity and that she blew through the fence a bit at that last hearing. So those are the issues that are in my mind. They tend to affect how I think this case ought to be resolved. I appreciate your comments on how you think of those things.
All right. Your Honor, thank you. And I always appreciate the court's guidance in terms of directing me as
It's
to
only
where I
me.
have to go.
Maybe there are other questions.
No, I understand. Your Honor, let me try to deal with those questions in the order that you've raised them. I do agree, if I understand the court's question correctly, that what the court needs to look very closely is Rule 9.203B with regard to what I'll call the jurisdiction of the Judicial Tenure Commission. It talks about the commission essentially not being an appellate court. It says very clearly, an erroneous decision by a judge made in good faith and with due diligence is not judicial misconduct. Now, what the commission, respectfully, I believe, has attempted to do is to turn that around on its head in 2 ways. First of all, they say in their responsive pleadings, well, Judge Gorcyca never proved that she acted in good faith and with due diligence. Well, respectfully, I think that's shifting the burden of proof, which is inappropriate. But secondly, and I think more fundamentally, I think everything that she did in this case, and I'm going to say with the exception of the hearing on the 24th, and I'll come back to that in just a moment, indicates her good faith and due diligence. And I would say to the court, and you, Justice Young, respectfully, we were prepared to indicate and present proofs that we believe that her handling of the contempt matter was entirely appropriate. We had expert testimony prepared to be presented, and we weren't allowed to do that by the master.
So wait a minute.
Yes.
Let's back up on that.
Sure.
I understand you say that the JTC did not make any findings that it's their burden to prove, I think, a lack of good faith and a lack of due diligence.
Yes.
And you say they flipped the burden by making her show it. And then, this is new to me anyway, you say that you were prepared to show good faith and due diligence, but you weren't allowed to?
No,
Right.
and I perhaps I misled you, Justice Larson. That
okay.
was my mistake. What I meant to say and what I meant to communicate is that we were prepared to indicate that we were going to put on expert testimony to show that her handling of the contempt proceeding was indeed proper and appropriate.
Proper and appropriate being different than exercised with good faith and due diligence? Or
I
what?
suppose it is different, but again, I don't want to leave the thought.
If something is appropriate, it would obviate the standard. You only get into the standard if it's incorrect in the first place.
I agree with that, Justice Young, and I certainly would indicate to the court that taken as a whole, her actions in this case.
Well, the first thing we have to sort out is who bears that burden, don't we, of proving that the effort being expended on a legal question is, in effect, in good faith.
I think it's their burden.
Okay.
But again, I don't want to leave the thought or the notion that everything, all of the facts in this case indicate her good faith. Her attempts to...
Yeah, but
But you don't dispute legal error.
I do dispute legal error. Legal
Well,
error with
didn't-
regard to the handling of the contempt matter?
Well, didn't she hold, I mean, correct me if I'm wrong.
Sure.
Didn't Judge Gorcyca hold someone in contempt for violating a court order that he wasn't under? If that's not right,
The
please
oldest
tell me.
child.
The oldest child. But you
Yeah.
have to really kind of parse through that very carefully. And with your permission, let me do
Yeah,
that.
good, thank you.
There was not a written order with regard to the oldest
Oh,
child.
I see, this is the oral order
And what
question.
happened was
Got it.
that customarily, not surprisingly, Judge Gorsuch would deal with all three children at the same time. On the day in question, on the 24th, the two children, we call them NT and RT, were actually ordered in a written order to appear for parenting time. But eventually what happened is that all of the children were brought into the jury room by the mother. Judge Gorcyca went so far as to actually write out, with the assistance of counsel, a script for the mother to read to the children, basically saying, please participate.
This doesn't answer the question about why it was not legal error. It was clear that the oldest boy, if my recollection of the record is correct, his parenting time with his dad was 2 weeks hence. At
Correct.
the time of the hearing.
In July.
He showed up because his mom brought him.
Right.
But I thought that the judge asked all the children, will you, as I have directed previously, engage your father in parenting time? And
did.
each one in front of her said no.
That's exactly right. And
All right, well, that's the answer, isn't it?
It is
As to
the
whether
answer.
there was error in assessing contempt against the oldest boy, who in fact hadn't had a direction to be in court, but was in fact in court.
yes,
Okay,
that is the answer.
all right.
Counsel, I'd like to ask a question.
I'd like to ask, can I ask you to answer my second question? Do you think that your client lost it? As much provocation as she had,
It's a technical legal term, lost it. It's a test.
blew through the fence, lost objectivity, showed partiality, and was insulting and caustic to the children in that hearing?
I think that she was frustrated. No,
Unquestionably so.
Okay.
And I would say provoked. I'm not, I mean, we are aware of this long history.
Yes.
Even so, judges are expected to, even when provoked, maintain a certain demeanor. Our canons require it. And I'm asking you, do you believe that your client observed the canons that require impartiality and that respect be devoted even to people who are querulous and perhaps undeserving of it?
I do in this sense, Judge, because, Justice, I think you have to look behind the motivation of the comments. Were the comments in isolation, in the abstract, were they harsh, were they demeaning? I would agree with that. But what was her motivation in terms of speaking in the way that she did? Was she attempting to demean the children?
I can concede that her motivation was pristine. I'm only talking about what I think the canons require, that we, even when properly provoked, we not lose the demeanor and civility that our canons call for. I think you agree that the canons do call for those things, correct?
They do.
All right,
although-
now my question is,
Okay.
did her demeanor conform to those canon requirements on that day?
And I'm going to say yes.
Okay.
Because,
Then I have the answer I need.
all right,
Well,
but I'm going to take that one step further, if I can, because if you look at the rules, 9.205B, it talks about persistence. And with the court's permission, it talks about persistent incompetence in the performance of judicial duties, persistent neglect.
Counsel?
Yes.
If I could ask a question, and I appreciate Justice Young's questions because I would like to kind of follow up on them a little bit.
All right.
And please, what's nice is that this is a significant case. We have time to go through all this. But I'm going to ask you some questions, and I understand you're going to make the argument about persistence. But I just want to really clarify. So again, it really is your contention that after Justice Young asked his questions, that the conduct of the judge was appropriate throughout this entire process?
It was appropriate when taken in the entire context of both the case and the day, Justice Bernstein.
Okay.
I do not believe that her
But let's
conduct
go,
amounts to
but then
misconduct.
if we can,
Yes.
I think this is important, then let's kind of go through it then, if we can, since
Sure.
this is the kind of argument that you're ultimately making. You have 3 young kids. The youngest is being 9. You really do feel that that's appropriate judicial behavior and judicial conduct to refer to the eldest, who I believe was 13, to refer to the eldest and tell him that he needs to learn about Charles Manson? You think that's appropriate behavior?
In the context of the entire case, I do, because the Charles Manson reference was first brought up by the children's own lawyer, by the guardian ad litem, when back in November of 2014, Judge Gorcyca asked him to prepare a report about what was happening.
But the children are not, we're not talking about juvenile offenders, correct? We're not talking, when I was at Northwestern, I used to represent juvenile offenders, and I understand there's a distinction when you're talking to children who, are perpetrating crimes. We're not talking about juvenile offenders, correct? We're talking about children who are in the middle of a custody case. Is that not correct?
That is correct,
Okay.
Justice.
So isn't that a little bit of a different standard at that point when you tell a 9-year-old, an 11-year-old, and referring back to the transcript, when you're referring to a 9-year-old who's crying at the time that, her brother is in jail, and does she want to go there too? And this is a 9-year-old. Do you want to go to the bathroom in front of other people who are going to watch you? Is your bed comfortable at home? Do you want to spend it's a 9-year-old. Do you want to spend until you're 18 years old in jail? I'm going to go back. I can see that I'm a young justice. But the question here is that appropriate judicial conduct in terms of the way that you handle yourself from the bench to a 9-year-old?
If you look behind the intent of those statements, Justice, I think the answer to that is yes, and let me please explain what I mean by that.
We have a lot of time. With no problem.
Judge Gorcyca was left with a very difficult circumstance. For 5 years, essentially, the children and mother were running the show. It's undisputed that they flat out refused to follow her orders. Now, after 5 years, she's giving the children a choice. And it's very clear, I think, if you look behind the pure words and the statements, that she doesn't want to send the children to Children's Village. What she wants them to do is to simply follow her orders.
Her motivation,
everything else.
We understand her motivation, I think. At least that hasn't been challenged, really. Has it?
I don't know about that. Because if you put this in the context of what she's attempting to do, is she harsh? Is she stern? Is she perhaps demeaning? I can understand people.
The whole question about her, it's not what she was her motivation for doing something. It's whether she acted on those motivations in a way that is consonant with her obligation to show civility and impartiality in discharging her duties.
And I understand that. I guess I just respectfully disagree with your perspective in this instance.
I'm only trying to explain what I think the canons require, so I can ask you whether you think her behavior, irrespective of her motivation, conformed to them.
And I, in the totality of the circumstances, I believe that. I earnestly believe that.
But the sign when she did, now again, I'm blind, so I can't understand visual cues, but my clerks explain it to me pretty well.
They do it to you all the time.
Yeah, they probably do. I would imagine that probably happens often in this building. In fact, I wouldn't be surprised if it's happening right now. But the question is, how do you explain my understanding that there's a gesture that you do to show like craziness, or that if you think someone's crazy, how is that appropriate? And I mean, I've listened to your entire argument, and I think you're doing an excellent job, and I think you're representing your client quite well. But help me to understand, again, according to Justice Young, I think the questions are pretty clear, help us to understand the idea for the insignia of crazy. How is that judicially appropriate?
Well,
In terms of your argument that you're making right now.
With all due respect, the commission did not find that particular fact to be the case. And I would
Well, you
indicate...
can't, wait a minute. They didn't find that she misled anybody about it, but
That's
it was,
right.
I don't have to make a fact finding. I saw it. Unlike my colleague, Justice Bernstein, I can see it. I didn't have to have somebody describe it to me. So it happened, but that's not the only thing. Look, I understand, and people can cause great perturbation. My question is, and you've answered it, so I don't need to ask again, my concern is I'm trying to decide in my own mind whether the totality of the affect that was projected by your client toward these children, her advocacy on part of the father, and I understand what she was attempting to, breached the confidentiality, I mean, the impartiality and respect and courtesy that judges are to accord even the most querulous, unpleasant litigants that come before us.
And I appreciate that. And to respond to that in part, don't we have to take that conduct into account in its entirety? Sure. In terms of both her entire...
You keep wanting to go to context. You keep wanting to go to context.
Yes.
So my question is, does context require us to give one lapse of judgment? Or is context something you consider in the greater scheme that might be a mitigating factor? I've been there. I'm the only one on this court that sat on a family court docket. I can identify the name. 20 years later, the family that was like this for me. I understand. People come into court, they throw all their problems in front of you. They're lying about each other. They hate each other. They don't care about their children. They throw it on you and say, fix it, judge. Week after week, holiday after holiday. I get it. But does that mean that at some point the judge is given a free shot, a momentary lapse of judgment, even if everything in their mind is in good faith, under the stress of the moment? When you look at it, do you have to say you get a free pass on this one because of the context? Or is it a mitigating factor?
No, I would analogize it closer to the first scenario than the second, Justice Sarah.
Why?
And because I think the rules require that. The rules talk about persistent incivility.
Persistent.
The
If someone came into court the first day and a judge berated them,
Right.
that would be misconduct. You don't have to come in 3 or 4 days in a row to get berated. So I don't buy the persistent
And
argument.
Justice Sarah, I can envision a situation and a circumstance where it could be a one-time situation where we would find misconduct. I don't believe, under all of the circumstances here,
That might be a
they exist.
mitigation. I don't understand, well, maybe I understand why you resist the notion that the wind-up to this day is a mitigating factor, but not an excusing factor. I mean, I just, if the conduct is inappropriate under the canons forbid it, period, right?
I respectfully disagree. I understand what your position is. I think you've
Well,
heard
I'm
me
asking the
articulate
question. I mean, I'd like to understand.
I feel like I understand both sides of this.
Okay.
And can I change courses? Do you
Oh,
think we're going
sure.
to get somewhere else?
Apparently not.
I just think while you're still up there, can we just move to the whether your client's response in the 28-day letter of having no memory of making the if that was right, why not just say that? Why isn't this speculation about what she may or may not have meant in that gesture, or what her motives may have been for doing it? Why isn't that misleading? Why not just say in the 28-day letter, I have no recollection?
You know, in hindsight, I wish we had done that.
Okay.
And I take some responsibility for that. I was part of the crafting of the response, and I probably wasn't as thoughtful and as careful with that as I
Had you
could have
reviewed
or
the
should have
tape
been.
by that time?
I'm sorry?
Had you reviewed the tape?
I had. But, and that goes to support, I think, the legitimacy of the position, or let me restate that differently. She had certainly reviewed the tape. The tape is the tape. And I understand what you're saying. I know what that gesture means. And what she says to me and what she said in testimony was, look, there's certain things I don't do. I don't give people the finger. I don't take the name of the Lord in vain. And I don't make that symbol or sign. I didn't intend that, period. Did she do it subconsciously? Maybe. She's asked to go back when she gets a 28-day letter and remember literally months ago what she was thinking at the time. That's difficult. Could the answer have been
If she
phrased?
had flipped the bird instead of made the crazy, I mean, you just say, I don't remember doing it, but I obviously did, and it was inappropriate.
Yes. And again, I acknowledge that. The answer could have and probably should have been better.
Am I correct?
But I take some responsibility for that.
Mr. Cranmer, am I correct in my assessment of the record that it appears that respondent has not in any formal way taken responsibility for her conduct and does not appear to regret the conduct? And if I'm correct in that assessment, should there be any legitimate concern that when other difficult cases arise, as they inevitably will, that there may be similar conduct in the future along the same lines that we've seen here?
I disagree with that, Chief Justice. And
You disagree with my conclusion that there's been no sense of responsibility or regret for these
I do.
statements?
And I could have...
Where is that in the record?
On the record, it could have been, again, explored more fully. I was the person examining the witness. Probably should have gone into that a little bit further. But I will tell you that there's been no question that she has acknowledged and recognized the fact that she made some mistakes on the 24th of June, and have no doubt about that.
The amicus briefs that were filed on behalf of your client from the Matrimonial Bar and from the Oakland County Bar Association talk about a chilling effect.
Yes.
Why would there be and I'm going to ask you a few questions about this, so I'm going to start with the question of, why is this going to have a chilling effect?
Well, I think because in many cases, but probably particularly in family law cases, I think the judge has to use all of the tools in his or her toolbox. And sometimes that means explaining some very harsh consequences and circumstances of the individual not following the court's order. And the hope is, as it was in this case, that by making those stark, harsh comments, the children are going to do just what they're supposed to do. Finally, after 5 years.
But do you feel the converse side to this? If this behavior is allowed, could have an ultimately converse effect, in which that this type of conduct could be sanctioned, approved, and ultimately continuing throughout this court system? I mean, don't you think that judicial temperament is a critical component? And ultimately, couldn't this have an effect in the opposite way, which is basically allowing for lower court judges to conduct themselves in this fashion on a regular basis without fear of penalty?
I understand your question, Justice Burstein, and my short answer is no. And again, I think as we apply this case specifically to Judge Gorcyca, the unrebutted testimony is that she has a phenomenal temperament on the bench, and that this conduct was not typical of her normal conduct.
But the question here is that you have a situation where you have children who lost their freedom. And I think that, don't you think that we have a little bit of a higher standard whenever a judge uses their power to, look, judges do all different types of things, but the contempt is a very powerful power that's given to a judge. I mean, it's really the highest form of power to deprive somebody of their freedom and of their liberty. And don't you feel that when you use that power, that we have to really make certain that that power is used appropriately and effectively?
Yes, I don't disagree with that. But again, you have to apply it to the facts and circumstances of this case, in my opinion.
Well, if you would apply it to the facts of this case, wouldn't the more appropriate way of handling it would have been to really I don't think anybody would be as concerned if this was focused on the parents' behavior, but here you're focusing on the children's. I mean, do you think that we need to look at this a little differently, because we're not focusing on the parents here, we're focusing on the children? If you have an issue with the mom or you have an issue with the dad in this type of a situation, I think, isn't it fair to say that we should approach that differently than the children here?
Well, there had been a focus on the mother in this case. If you recall from the record, let me perhaps
No,
just
I
finish.
understand. Look, I know this record backwards and forwards. What I'm
All right.
trying to say to you is that what I'm trying to ask you is that the issue that I think is of concern is the issue of the fact that you are dealing with the children. You're dealing with the children. You're telling the children they have to have a ultimately, look, you know what? The court can give certain orders. The court can say, be here at this time, be here at this place. But you're giving an order to a young child that they have to have a relationship with their parent. You are going to have a relationship with your parent. Otherwise, you're going to jail. I mean, let's look at that. Isn't that a little bit of a cause of concern?
Think about the alternative to that,
Okay.
Justice. And that is, what she very easily could have done, and maybe in hindsight should have, was thrown up her hands and say, well, you know what? I've been trying for 5 years, children, to get you to obey my orders, and it looks like it's not working, and you're not going to do that. So, Father, I'm sorry. Have a nice day. Clerk, call the next case. I see that my time is up.
I have one question I'd like to ask you.
All right.
The JTC has recommended that there be public censure and 30 days suspension without pay.
Yes.
How would you resolve this case?
How would I resolve it?
How do you recommend that we do it?
I recommend that you come back with a finding of no misconduct and dismiss this case.
Can I ask a question about context? We've talked a great deal about the context of this case. I'd like to follow up on Justice Zara's question about the context of Judge Gorcyca's career. If we disagree with you and believe that there was real, tangible misconduct that occurred on this day, and I'm not saying that that will in fact be our conclusion, but if we do reach that conclusion, how is it that we weigh the rest of Judge Gorcyca's career, which seems to be without blemish as far as I'm aware, with what we would have believed was a very bad day on her part?
Well, I think under the Brown factors, that would be a significant factor that the court must weigh, and I'm sure the court would weigh. But I'm very concerned.
How do we weigh it, though?
Well,
I mean, Justice Zara is certainly correct that there's no free ride in terms of, you know, you're allowed one bad day or 2 bad days or X number of bad days. I'm saying if you accept the premise that this court is in fact troubled by this day and feels that there was some misconduct, how is it that we ought to try responsibly to balance that bad day with the entirety of the judge's career?
and maybe I'm just not articulate enough, but I think you've said it just at the very end of your question, Chief Justice, and that is that you take a look at this one day, if you conclude, as your hypothetical does, that this was misconduct, that it's aberrational in the context of the entire case that she was handling, aberrational in the context of her entire career, and directly contrary to the other testimony that was in the record about her demeanor generally. There's no other evidence, none, that she's ever been disciplined before or questioned about her temperament or that anything else in this particular case caused the commission or the Judicial Tenure Commission any angst whatsoever. That has to be, I believe, a factor that the court weighs and weighs heavily.
Counsel, if I go to a surgeon and, you know, my life is on the line, I go to a surgeon, is it okay for that surgeon to have a bad day? If I'm the one who's being operated on, is it okay for that surgeon to tell me or say to my family, if, you know, if it doesn't work out, that I just had a bad day?
I think I understand your question, Justice Bernstein.
I bet you do.
I'm not sure I can answer that. I certainly, I'm not sure I can answer that.
And even more, Justice Bernstein caused the bad day.
Which is what usually happens.
Seriously, he caused the bad day. Are you allowed to screw up on the surgery, even incidentally? You didn't intend to, but your hand started shaking, and you couldn't do that surgery because of what he said to you right before he went under.
Trust me, it can happen.
Probably has happened.
I mean, that's what we have here.
And counsel, look, I'm very sympathetic, but the issue is that in certain situations, when you are sentencing someone to jail and you're taking away their freedom, and in this situation, telling a 9-year-old that they're going to spend until 18 in prison, I mean, do you think you have the right when you're in this position, when you have this kind of power, and you're talking to a 9-year-old and you're telling them you're going to spend your whole high school in prison? I mean, do you have the right to have a bad day like that?
Respectfully, I disagree with the premise of your question. She wasn't sentencing anybody to jail.
She said it in the transcript. It said your brother is in jail.
She was telling the children very clearly, you have a choice here. Please choose the right thing. Just have parenting time with your father. I can't make you, you're right, love your father or have a relationship, but I can order you to have parenting time with your father. Make that choice. Don't make me...
And if you don't, you're going to spend your high school career in jail.
No, if you don't, and if you refuse to follow my orders, as you have for the past 5 years, finally, now, there has to be some consequence. That's not inappropriate as far as I'm concerned.
Mr. Kramer, before you leave us, I guess my question is, we've heard all about context, and the respondent judge has a good reputation in the community, no apparent record of disciplinary action in the past. You've, I think, explained well to us that this is she was under the most trying of circumstances on this day with the most difficult of cases. I think you've also made it clear that her motives were good. I think all of us accept that. But there's some question about her methods on that particular day. Do you believe this is the type of situation, and I guess I would add to that one other component that you mentioned that I think we've sort of given short shrift to, which is that our rules talk about persistent conduct by the judge. Do you think that the judge's conduct on this one occasion, that it's too late for this at this point, obviously, but perhaps this process should have been steered toward a private censure?
I absolutely believe that that's what should have happened in this case.
And was that ever something that was discussed?
It was.
Well, I won't pursue it any further, but I don't want to get into what went on there, but I do have my own questions about why we're here discussing this case in this forum.
Okay, well, thank you, Mr. Cranmer.
All right. Thank you.
Good morning, Your Honors. Lynn Helland, together with Margaret Rainier for the Judicial Tenure Commission. Throughout the proceedings, and again today, especially in response to Justice Bernstein's questions, respondent has framed this case as a referendum on whether or not judges have the power and the ability to enforce their orders. It's not a referendum about that. Of course, judges do have that power, but it is a referendum about whether Michigan permits its angry judges to insult, berate, and ridicule children, to demonstrate a loss of impartiality, and with the barest of nods to due process, to find a child in contempt for violating an order that didn't exist. And respondent's framing here, and before, has rested on a very sanitized version of the facts. I know the court is familiar with the facts. I just saw it in action. I expect to see that in action again in just a couple minutes. So I'm not going to do a summary of the facts, but I do want to talk about the facts that I think respond to Justice Young's question. Is this error or is this misconduct? I know context has been tossed around a fair bit. I'm going to toss out just a little more context. It's important to note that whether rightly or wrongly, these children truly feared their father. They were really young when the parents separated, ranging from 2 to 6 years old. For the next 7 years, they barely saw their father. They were under the control of their mother. Until these proceedings began, they had hardly seen their father. Respondent well knew this because she had the children evaluated various times, and those evaluations demonstrated the children's fear. It's also important that until these children were held in contempt, they had never appeared in respondent's courtroom. until that day, the whole focus of, not the whole, much of the focus of respondents' frustration and anger was on the mom. The day before the children were held in contempt, mom appeared in court, and on that day, respondent told the mom, look, if parenting time doesn't improve, you're going to be in trouble. You could be in contempt. We could show cause you. That same day, June 23rd, respondent entered an order that required RT and NT, as the court knows, but not LT, to show up for parenting time on June 24th. On that day, June 24th, respondents' focus suddenly and really inexplicably shifted from the mom to the kids. LT, who had no obligation to be there that day, does show up and oddly, suddenly finds himself the subject of a contempt proceeding. Respondent never explained why it is that LT went from somebody who wasn't even supposed to be there to somebody who was being show-caused. LT was represented at his hearing, but only just barely, because in the span of no more than 40 minutes that morning, respondent told all three children that she was going to show cause them, but not the mother who she'd been pressuring the day before. Respondent appointed counsel for each child. Those counsel were located, dropped whatever they were doing, met the children and took on the representation, and the hearing against LT began. Clearly, LT's lawyer had no chance to review whatever order there might have been that his client was accused of violating. Respondents rushed to get to that hearing, and her handling of it show her eagerness to hold LT in contempt. His first words were to apologize to the court for whatever he had done to her. After that, he said that because he had seen his father hit his mother, he wasn't going to talk to the father. Respondent immediately found him in contempt. There was no discussion, no anything. And she found him in contempt, although he wasn't under any duty to even be there that day. She found him in contempt without bothering to explore the justification for his fear or not wanting to talk to his father. After holding him in contempt, she began to give reasons. She told him that she had ordered him to have a healthy relationship with his father. She had. There's no such order in the record. It's hard to imagine that there could be an order like that, to tell you the truth. She told him that she had ordered him to talk to his father. Again, there's no such order in the record.
Like opposing counsel, you think we're hard of reading, don't you?
Not at all, Your Honor.
Can you get, these are all facts in the record. I really would like you to help me understand how to resolve these issues that you've made your client, the JTC, has made a recommendation. I'm concerned that the JTC has slipped over the edge of being concerned as its primary mission with ethical or unethical conduct, and now has become a mini court of appeals on legal errors. And I'm not sure why, whether the respondent correctly met all of the requirements to impose contempt on these three children is a matter of your client's concern. And then the other side, I'm trying to figure out, if I determine that there was unethical conduct on this day, what the right sanction is. So those are the things that are floating through my mind. You can continue your factual summary if you'd like.
I appreciate your concern, Your Honor, and my apologies. I was trying to address it. Let me say this, though, about the Tenure Commission and its role. We get, as you know, hundreds of requests for investigation every year. The great majority of those we dismiss because they raise appellate issues, not because they raise ethical issues. So that's the first analysis we undertake when a case comes in. This case is different. The question here is, did this respondent violate the canons? She certainly committed appellate issues that are subject to appeal. That's not what I'm trying to talk about. What I'm trying to talk about is she held a child.
Well, the commission talked about it in its recommendations. The
Well,
master did too.
I'm sorry?
May I try?
Sure, thank you. Help me.
You've been-
Translate.
So here's what I'm struggling with that I think is related to what Justice Young is struggling with. So it seems to me that your position is that she made a legal error and did it while really angry. That the combination of an improper legal ruling, just assuming that it was improper, and I want to ask you about that in a moment, on the contempt, combined with making that incorrect ruling while really mad, really frustrated, or worse, inappropriately demeaning towards the kids, that combination translates a legal error to an ethical violation. And I'm worried about that because I feel like we're going to have to build a lot of judge jails.
What she
Because
said.
I'm going to invest in judge jails.
No,
Because I think a lot of judges make legal errors, and we have a process for fixing that. That's what the Court of Appeals does.
And I respect that. We're very sensitive to legal errors
Is
versus more.
that in fact an accurate characterization of what the JTC concluded? She made a legal error and she made it while she was mad and in violation of the canons. Therefore, it's
No, I don't believe that's an accurate characterization.
Well, then how else could we determine that if it was a legal error, and again, I'm going to get to that in a minute, that it was in bad faith? How would we determine that?
Let me say
Based on
first
this
about
record.
bad faith or good faith and due diligence. I respectfully suggest those are affirmative defenses. The burden is on the respondent to demonstrate those.
Oh, wait.
Why?
Why?
If I could draw on other law that I'm familiar with, because I don't believe there's any discipline law that addresses that, it's a classic affirmative defense for a defendant to have to demonstrate. If good faith is a defense, it's up to the defendant to introduce evidence
Well, wait a
concerning
minute.
it.
The threshold is your client doesn't have any jurisdiction over legal appellate error.
Right,
This is an
correct. I agree.
exception.
I agree.
And so who bears the burden of establishing that the commission has authority to look at a legal error?
Well, that falls on
All right,
us.
well, that's the whole point. If this is the exception, don't you bear the burden of saying, well, this is within our jurisdiction because we satisfied the exception?
Yes. And when a legal error so departs from a reasonable application of the law or the facts, that is something that we at least have to take a serious look at. I do think you join it here.
Well,
I
I think you've just acknowledged legal error plus anger or some other inappropriate conduct equals legal errors in our jurisdiction.
Legal errors are within the court's jurisdiction when they rise.
When they're flagrant, yeah.
Yes.
If a judge were to say,
I don't care what the law is.
yeah, that is the law, but I don't care because I don't
Exactly.
like you, and so I'm going to do it differently. Okay,
right.
I say go for it with that.
Right. And there are different ways for a legal error to be flagrant. One way is to
Right.
say, I don't care. Another way is to just do something that is in total disregard of the facts you have before you.
Did anybody object here? So ordinarily, it's on counsel to object when a judge is making a legal error.
Nobody objected here, but that gets back to the process that
Yeah, but there's a legal there. I understand the children's own appointed lawyers had precious little time to familiarize themselves with their new client's interests. But there are other people in that courtroom. This is a family court setting, and there are a lot of interests, including legal, who would have been in a position to say, wait a minute, the oldest boy doesn't even have the obligation to be here today, Judge. None of that. No, there was no help to this judge in this circumstance.
Well, I will agree with that, and I will say that this judge started a train moving. Nobody jumped in front of it. It would have been better if somebody had jumped in front of the train. But the fact that the judge started this train moving, it plays out in the way she then treats the children during the hearings. The hearings, the words she used, the tone of her voice, you've seen the video, those were not just, it didn't arise spontaneously in that moment. They are part and parcel of this
But that's what I think the
proceeding.
JTC has authority over. I'm not quite agnostic. I'm looking for you to persuade me, frankly, that you have any authority to challenge the respondent's so-called legal error in the contempt proceeding. I am not at all, I think there's a conflation here. That's my concern, that you are just sweeping into the JTC's jurisdiction on ethics legal errors. That's where I'm most uncomfortable with the recommendation of the JTC at this point.
And I would like to separate, again, what I think are the two primary errors here. There is the way respondent treated those children.
Okay.
Clearly, I think everybody agrees, no problem there. That's within our jurisdiction.
Okay.
Okay. With respect to the question of legal error,
Please stay in front of the
I'm
microphone.
sorry, I apologize. With respect to the question of legal error, we agree. The great majority, the huge majority of legal error is not our concern. But
And I'm trying to figure out why this has become your concern.
because it was so blatant, because it showed, it was a product of the animus that animated these proceedings. And when I say it is so blatant, I say it's
Then
blatant.
wouldn't you have to make a finding that she acted in bad faith? I mean, I understand, like, as Justice McCormick said, that a judge could say, I know that there's no order here. You're not under any court order, but I hereby hold you in contempt anyway because I don't like you, I don't like your race, I don't like your gender, like something bad. Could totally, and that would be judicial misconduct. But you would have to make a finding to show that it was made in bad faith, right?
Well,
Or we would have to make a finding from this record, since we reviewed
Yes,
de novo.
I agree, except I would say the words bad faith sound like they could be a term of art, like a finding of no good faith, and I don't think that's accurate, but I do think this record supports, I do think the commission found that this was such an unsupported finding under circumstances that demonstrated animus, that's exactly
Well, I
what...
thought you said that the commission didn't even believe it had the burden on those, on that point.
Well,
I'm suggesting to you, I'm not at all confident that that's the correct position, since you don't even have jurisdiction to consider legal issues unless it's within the exception. And if you're trying to own that exception, you bear the burden, it seems to me, of proving lack of good faith or whatever the other thing is.
Okay, I guess I characterize it slightly differently, but maybe it's a distinction with a little bit without a difference. I would say if there is blatant disregard for the law and inexcusable, we have jurisdiction to take a look at that. It is a defense to that, as to which we may or may not need to make a finding. It is a defense to that if the judge actually acts with due diligence and in good faith.
Okay, wait, counsel, but here's what we're all worried about. We're worried about opening lots of judge jails.
Yes.
So let's say that I'm a judge in the trial court and I have a busy docket and I make a legal ruling that is directly contrary to controlling precedent from this court, from the Michigan Supreme Court. But nobody brings it to my attention. Neither counsel for the plaintiff or the defendant says, Judge, that's legal error. But it's blatantly wrong because there's controlling authority. But nobody says, hey, you should read this case, Judge.
There's no plus there. There's no additional indicia there as we have here, which I think gets back to what is perhaps the semantic distinction.
But don't you have the burden to show what's the plus?
Yes. If it's, I don't know whether, I think it's an affirmative defense. I think there are other ways we could get there. But in this case, the evidence shows no due diligence with respect to this ruling, and it shows really very little good faith with respect to applying the law of contempt. So that record exists if those are part of our burden.
Counsel, do you think there should be a higher burden for criminal sanction versus civil?
No, I think when you're locking somebody up, the sanction, the burden for doing it, there are different criteria. But I don't know that the burden is either higher or lower.
I guess the question is, do you think that the judge has a higher standard they have to adhere to as it pertains to this line of questioning if a person is losing their freedom versus another context where there isn't a contempt situation or freedom being lost?
Oh, sure, yes. I think when the consequences for the litigants are higher, the judge has something of an obligation to be more careful. Yes, I do agree with that.
Would you admit that if the judge said all the same things and everything occurred exactly as it did in this record, but then instead of saying, I find you in contempt, would say, I take this matter under advisement for 2 weeks. You go home and think about whether you want to have a relationship with your father or spend the next 6 years in Children's Village, if that's what occurred. And then when they come back in 2 weeks, intensive family reunification, counseling, and all the rest, if that would have occurred, would you admit we wouldn't be here right now?
With or without the demeaning language?
No, all the language is the same. Everything's the same except there's
to
no
think about it.
sending you to Children's Village, no finding of contempt.
I guess I don't know the answer to that, Your Honor. I struggle with the alternate universe situation, but I would
We
think
have to
that-
figure that out, though. You may not have to, but we have to kind of think about the next case.
So here's what I...
The fact that you don't know is telling to
Actually,
me.
so do we think about the next case, so I agree with that. I would say the abuse of the children here was so egregious that, no, we would probably still be here, but the sanction, our recommendation might be different.
Do you agree that it's your burden under the rules to establish misconduct to show persistence, as counsel mentioned under Rule 9.205?
Is
Persistent failure to treat persons fairly and courteously, for example?
No, there is a provision under which persistent failure to treat people fairly is itself misconduct. But as Respondent admitted in their brief before this court, a single instance of abusive conduct can be misconduct when it's prejudicial to the administration of
And
justice.
that's
And
relying on which case? On the Hocking case?
I'm going to be hard-pressed, Your Honor, to give you the site. I apologize.
It seems strange to me, though. I mean, I recognize that case, of course, but the rule speaks of persistence. So you
Well,
just don't
the-
think that's a requirement? You think a
No,
one-time?
no, I think there are separate ways of having misconduct. If you have persistent treating people poorly, but maybe it doesn't arise to the level of prejudice in the administration of justice in a particular case, that's misconduct. But if you lose it in a particular case and you prejudice the administration of justice, that's misconduct.
So your allegation, as I'm looking at this rule, is that her conduct, it's not habitual intemperance or intemperance at all. It's conduct that is clearly prejudicial to the administration of justice.
That's correct.
And that's, but it's weird if you have a rule. So we have a rule that says misconduct in office, comma, persistent failure to perform judicial duties, comma, habitual intemperance, comma, or conduct that is clearly prejudicial. So your argument is that although habitual intemperance is one, a one-time could be conduct that is clearly prejudicial?
I believe this court has previously so held, Your Honor, and I think that makes good logical sense. You don't want
It's a
intemperate...
catch-all.
I'm sorry?
It's a catch-all. Conduct that
it's
is
a catch-all.
clearly prejudicial.
Right.
Do you believe the conduct here was persistent?
No, I believe it's confined to this day, and I'm not going to claim that conduct in a single pair of hearings involving the same family on one day is persistent.
Mr. Helen?
What's your response to my earlier suggestion that a private censure might have been an appropriate way to proceed in this case?
Your Honor, I'm a total newbie here to this case, so even if that were on the record, well, if it were on the record, I presume I'd be
Well,
familiar
leave
with
aside
it.
whatever the procedural history was, because I wasn't trying to get into any private discussions between counsel, but just looking at it cold, what's your reaction to that?
I think private censure probably jumped off the table with the failure to accept responsibility.
Do you have authority to speak for your client on that point?
No. I mean, I can speculate, but no.
I don't think you even have authority to deviate from what your client has recommended to us, do you?
And I don't intend to. I was trying to respond to Justice Viviano's question about that alternate universe, but if you prefer that I don't.
I wasn't trying to get you into hot water, just asking for your response to my thought process.
Well, let me ask you, if the court were less inclined to believe that the legal error here, the claimed legal error, was part of the mix, should that affect our consideration of the whole sanction that the commission has recommended, the public censure plus 30 days without pay.
I think if the court concludes that respondents' animus didn't motivate her to lock children up improperly for some period of time, that does have an impact on the appropriate sanction.
Well, you keep saying animus. What was your view? What was her animus, respondent's animus in this case?
She was angry at these kids that day.
Why?
The record is not
She
clear
just didn't
on
like
that.
them?
That's where respondent likes to
No,
talk
they
about.
were in
Did she
front
just
of her.
not like them? I mean, what's the animus? Peter?
The animus is...
She didn't like how they looked?
She
She didn't like how they behaved? I mean, what's the animus here?
Well, again, the record isn't super clear on that.
Oh, wait a minute. She brought them in front of her. She said, look, I've been trying to get you to deal with your father. You're not
Right.
doing that. Are you going to do it today?
No, I agree. That was her focus that day. Why she
Well,
was...
I don't
Do we have any
understand your
reason to
position.
conclude it wasn't her focus throughout the entire case? Trying to get them to comply
No,
with
she
court
was
orders?
she was trying to improve parenting time for years.
So was
I
her
completely
animus,
agree with
was
that.
she angry? Would you agree that she was angry because they wouldn't comply with the court's
She was
orders?
angry because she perceived that her orders to improve parenting time weren't meeting
So
her
it wasn't
standards.
when you say animus, we're not talking about something that's sinister
No,
or
I'm sorry.
inappropriate or...
Her anger, her...
She's upset because they're not complying. They're not doing what she's ordering them to do, right?
Right, yes, I agree.
She has a right to be upset.
I agree with that.
Okay.
Yeah. It was the way she carried out her demonstration of being upset.
Right, her
That's the
methods, her
problem.
methods.
Right.
Mr. Helen, I'm sorry. You know, as I reflect on this case, I always, after a few moments, get back to what to me is the 1,000-pound gorilla in the room, which is the fact that as a product of this arguable legal error, this child was confined for 17 days at Children's Village. Yet immediately after I reflect on that, I reflect back to the fact that Judge Gorcyca explicitly gave the key to that child being released to the child's father. I can't imagine many fathers who wouldn't try to turn that key as quickly as they possibly could. Yet the father here, and it's not no excuse to me that he was in Timbuktu or wherever he was, he did not exercise that effort to turn the key. Why shouldn't that weigh heavily on the court in trying to assess whether this should effectively be viewed as a 17-day confinement imposed by the judge, or rather what she might have reasonably anticipated would be more like a 17-minute confinement before the father exercised the authority that she had invested in him to release the child from Children's Village?
Two quick things in response to that. I do think it wasn't on respondent whether the confinement ended up being 17 days or some other period of time. Other circumstances could have intervened. She did give those keys to that father. But the other point I'd make is she had a chance.
And might she not have reasonably expected that, like most fathers, he would have done everything possible to exercise that authority that had been given to him?
She might have. She might. That doesn't appear in the record, but she might have. But the other point I'd make is she had a chance on the day of the hearing to end this process. When she held LT in contempt, LT's mom said, "Let me try to talk to him." She turned that down. That was a chance right there to stop this train from moving.
You talk about the train, and you seem very interested in sort of grading the judge's decision-making all along this process. Do you feel that putting them in Children's Village for non-compliance with an order itself deserves a poor grade, or is something that's inappropriate for a judge to do?
Well, I go back to the fact that there was no order that LT violated.
If there
That's
had been.
that's not my question.
His question is if there had been an order.
No. If a judge has an order, and if the order has been willfully not followed, or it needs to be coerced, I think Children's Village is
An appropriate sanction.
Probably appropriate.
Does there need to be does there need to be a written order? And do you agree that the judge in fact gave an order to the child in the courtroom, and the child said he was not going to comply? And
I don't believe there needs to be a written order. I don't believe the judge gave any order to the child in the courtroom before holding him in
If we
contempt.
disagree with you, then what is the outcome?
Well, if you think there was an oral order, and you think that he then deliberately violated that order, then it becomes reasonable to at least hold him in contempt.
And you think that is,
And send him to Children's Village.
Well, I mean, it could be under some circumstances.
But again, the sanction of sending a child to the village is not egregious. It is an appropriate one if the legal basis is clear. So your position is that it is beyond cavil that what happened in front of this judge was not a contempt in her presence.
That's correct.
Nobody could challenge that.
I don't see a basis for it in the record, Your Honor.
All right. I understand your position.
Mr. Holland, I welcome to the JTC first.
Thank you.
Yeah. Isn't this fun?
Yeah, I'm loving it so far. Yes.
And we understand that you've been on the job 4 weeks, and that the position that the agency has taken up until now, you were not steering, and that you are a lawyer representing a client. Having said that, can you give me your best argument for why the costs and fees? I assume that $12,000 is the cost of the entire proceeding.
Yes.
Why that makes sense and isn't sort of extreme for what's gone on here? I mean, you've alleged that there's one statement, and you didn't even find that it was a misrepresentation. You found it was misleading. Not you, but how do you justify a $12,000 award of costs?
I justify it in 2 ways. First, yes, the statement was misleading. This was not an effort, and Justice Bernstein, I'm circling my temple right now.
That's what we do in conference.
Just another day at the court.
But that was clearly not an effort to talk about the forward motion of therapy. So clearly the statement was misleading. 9.205B speaks very simply of misleading statement
Yeah, but the
leads to costs.
JTC, at best, they were equivocal.
But it's not. I mean, it didn't cost $12,000 to prove that was misleading.
No,
I mean, this was
but the
big-
rule doesn't parse that out.
Yeah.
The rule doesn't even require a connection
Okay.
between the misleading statement and the cost. The rule just says misleading statement and costs.
You're on the hook for costs. Okay.
Yes.
For the entire cost of the proceeding, if you make any statement that is not false,
It's
well, that
misleading.
is not intentionally false, I think, is but it's just misleading, you pay the whole bill.
The commission here gave respondent a huge break to find a distinction between the misleading statement and an intentional misrepresentation. But I would say, yes, the way the rule is written, a misleading statement results in costs.
Thank you, Mr. Holland. Are there any further questions?
Thank you very much.
Thank you.
On behalf of my client, I urge you to adopt all of the recommendations that the commission made.
Thank you.